Good afternoon, everyone, and good morning to those of you in the West Coast. Welcome to our program today entitled Litigation Basics for Nonprofits, What to Do when a Complaint or Subpoena is Served, and Other Tips and Strategies. First off, I need to give appropriate credit for the topic of today's seminar, which was suggested by one of our participants here, Maya Grassi from the American Society of Anesthesiologists. It also happens to be Maya's birthday today. So if you can all wish her a happy birthday, I know she would greatly and embarrassingly appreciate that. Thanks, Maya, for the great suggestion. And it really was a great suggestion. This is an area that, of course, as lawyers and outside counsel here at Venable, we of course do a lot of litigation, both on the on both sides of the fence for nonprofit organizations. We're the ones that the nonprofits often come to when they get sued, when they get hit with a complaint, when they get hit with a subpoena or some other sort of investigation from a federal or state government agency or congressional committee. This is an area that we have extensive experience and expertise, and obviously that's the perspective we're going to bring to you today. But the reality is that most nonprofit organizations don't have that much experience with litigation and investigations. Fortunately, most nonprofits don't ever have to experience what can be a very unfun and unpleasant experience. But being prepared, knowing some basics in advance, knowing some kind of basic tips and strategies is going to make you much better equipped to deal with these issues when they do arise, and that's the purpose of today's program. We have a nice crowd here in D.C. That joined us for lunch, and we have a very large crowd of, I think, close to about 200 people on the telephone across the country today. So we're glad all of you could be with us. I should have introduced myself. I'm Jeff Tenenbaum, chair of the nonprofit organizations practice here at Venable. As many of you know, because many of you are repeat attendees, this is part of our monthly series that we do on nonprofit legal issues. Am I advancing the slide? Yeah. This is part of our monthly series that we started about a year and a half ago. It's been very popular. I want to announce actually 3 upcoming programs. Just yesterday we nailed down our December program as well. Next month on October 16th, we're going to be doing a program entitled You're Not Covered for Everything, making sure that your nonprofit's directors and officers insurance coverage matches your expectations. And on November 13th, we're going to be doing a program entitled Top 10 Real Estate Leasing Issues for Nonprofits. The December program is actually not completely nailed down yet. That's going to be on December 11th, though, if you wanted to mark your calendars. We're fortunate to have with us today 2 of my colleagues who work regularly with me and with our nonprofit organization clients. Caroline Gately, to my immediate right, is a partner, trial lawyer with over 20 years of experience in litigation, primarily commercial transaction disputes. Caroline has worked with many of our nonprofit clients, including some of you here in the room, in connection with lawsuits, in connection with third-party subpoenas, and in a number of other areas. She's a really terrific litigator, very smart, very aggressive, and very adept at resolving matters in a manner that's kind of most effective and efficient for our clients. Sometimes using unconventional tactics in order to do so, but always and seemingly with a great track record and great results. She's really one of our premier litigators here at Venable, and we're very fortunate to hear from her today. Dave Feinberg, to my far right, is an associate, also a commercial litigator, works closely with Caroline and others in our litigation group. And he also has a number of years' experience doing this and doing it with nonprofits and for-profits, and is going to have some great insights for you here today. A few logistical matters, handout materials. Those of you in the room have the paper handouts that have a copy of the slides, along with some related articles and other PowerPoint presentations from other programs that we've done on related topics. Those of you on the telephone should have had the slides emailed to you. Tomorrow, everyone here in person and on the phone will get an email with a link to the recording of today's program, as well as all of the handout materials. Feel free to share that with colleagues and others who might benefit from it. As many of you know, we keep the recordings and streaming PowerPoints of all of our monthly nonprofit legal seminars on our website. You can always find those at venable.com/nonprofit/recordings. In terms of questions, we have the program today is really divided up into 6 segments, and you'll see, and our speakers will make clear kind of those 6 dividing marks. What we're going to try to do is take questions, if you have questions, after each of those 6 segments. So the speakers will prompt you. Feel free to ask questions. Then, of course, if you want to save up your questions and ask them, hold them for the end, that's fine as well. But we like to encourage you to ask questions during these kind of logical stopping points in the program. Raise your hand for those of you in the room, and I'll repeat our speakers will repeat the questions for the benefit of those of you on the phone. And those of you on the phone, as you know, pose your questions using the chat feature on the webcast software. So with that, and actually one more thank you to our marketing specialist, Jamie Fitzsimons, who always does a terrific job in helping to organize these events. We're fortunate that Jamie's still with us because she's about to have her baby, and her last day in the office is tomorrow, so she made it through to this program, and we wish her all the best with her soon-to-be-born baby. And with that, I'm going to turn it over to Caroline to get us started. Caroline?
Thanks, Jeff. And thank you all for being here and being on the line. And it's a beautiful sunny day in Washington, D.C., and you all chose to come here and be in this sort of boring conference room. So I appreciate your being here today. And obviously the hope is that we impart something to you that you don't already know. But the goals for today is something I want to talk briefly about. The impetus for the presentation was the thought that not everybody has the luxury of dealing with this on a day-to-day like we do. And so we are by design addressing our presentation to an audience that we are assuming has relative unfamiliarity with the legal concepts and the issues that come up in these areas. I know we have some lawyers in the audience, and some of these concepts will be familiar to you, but we are trying to educate sort of a lay audience for those of you who have to deal with these issues, or in-house counsel who don't have to deal on a regular basis. So first I want to talk about the agenda, talk about the goals, what we want you to take away from the program today, talk a little bit about the actors involved in the topic that we're here to talk about, and the forum, really fora. It's I guess the Latin plural for forum is fora, but it's a forum. I put forum. Forum seems kind of silly. Defending against actions. This is sort of the meat of what we're here to talk about, and we're going to go through a number of different kinds of scenarios that your organization may find itself confronted with, and they're listed there on this first slide. And then if we've got some time, maybe talk a little bit about things that you all can be doing in your organizations to be prepared for the day that comes that one of these kinds of legal actions is initiated, or your organization is involved in one of these kinds of actions. And then finally, if there's time, we'll take some final questions and answers. As Jeff mentioned, I'm going to welcome questions and answers as we progress through the slides. And just a word of caution, we always say this to our audiences, we can't give legal advice, and I may say, your question presents a very interesting situation, probably crosses over into the area, or my answer would cross over in the area of giving legal advice, so I can only keep my answer on a sort of a general basis, and don't take that personally. It's that we're bound by the rules of ethics to not give legal advice where we don't have a client relationship established with you. We'd like to have a client relationship established with you, but if that were the case, we wouldn't be talking in a room full of people about your legal problems. So I may address your question with that preface. Okay. So moving to the goals. Again, modest goals, become familiar with the common types of legal actions that your organization may find itself involved with, and the associated vocabulary with those items. Number 2 is give you a sense of how to assess a level of threat or urgency. Some, as you'll see, some kinds of actions are the kind that should make you run, dialing up your CEO right away, and some aren't. So we want to give you a sense of what that spectrum is. Obviously appreciate the issues that are triggered with those different types of actions and how you should react. in that first intake instance. And then, as I said at the end, if we can have a little time to talk about some tips for being prepared for when that day comes. Okay, so the actors. The issue here is, who are these folks who may have a beef with your organization or involve your organization in their beef with others? Where do these threats exist? And we kind of lumped them into two categories, the government and private parties. And the government sort of separated into two parts, the federal government and the state government. The Department of Justice, that's one aspect of the federal government that may want information from your organization, or who may have a conflict with your organization, or conducting an investigation that could develop into a conflict with your organization. Agencies of the United States government, Dave will talk quite a bit about this, EPA, SEC, FDA, I mean, they're all, you name it. And any one of those agencies has, as you'll see from Dave's portion of the presentation, the power to request information from your organization and conduct an investigation. The FBI, Congress itself through its committees. And similarly, the state government, attorney generals have the power to request information from your organization, and naturally to sue your organization. Agencies of the state government, inspector generals, and the state legislature itself, just like Congress. Now, on the private actor side, there is, as Jeff mentioned, sort of a perception that maybe nonprofits don't get quite as involved in litigation as much as a for-profit business. But again, there are folks out there who may want information you have, or have a conflict directly with your organization. And thinking about those in the groups of where those internal threats might lie. You might have, naturally a beef with an employee. Members of trade associations. I handled a fairly extensive litigation with a former member of an organization against the trade association itself. From external sources, you all do business with vendors, and vendors can be the litigant themselves, or they can be someone who made a payment to you, who then that vendor ends up in bankruptcy, and you're on the receiving end of a request by a bankruptcy trustee to return the money that you've received. Assisted a client with a situation with a vendor for their contract for the arrangements in the hotel for their convention, their annual convention. There was a conflict that arose under that kind of an agreement. So you all have those kinds of relationships, no doubt, with the vendor world. Other litigants, and this is one where I think fairly with some frequency confronts your organizations, folks who want information that they think you have or that you have. Your organization may be involved in standard setting, and they want to develop some portion of their private dispute in connection with standards that apply to the industry that they're in. Your organization may be involved in data gathering, and they want a quick stop for recreating the data that you've already gathered and piggyback off of the work of your organization. Or the litigants may want to establish that a member of your organization had knowledge of an issue, maybe a health and safety issue. So you've got a products liability lawsuit, and the plaintiff wants to establish that the defendant, who is a member of your organization, was aware of some concern that your organization maybe alerted them to in a newsletter or some other such thing. Your organization may be involved in certifying folks in the industry, and so there may be information there that's useful to those private litigants. Trade associations, being a collection of members who come together and talk about common business issues, are often targets for rooting around for information about effects of those talks on competition, or perceived effects or alleged effects on competition, so we get in the whole antitrust area with those issues. So lots of different scenarios in which your organizations, although not engaged in for-profit business, may become of interest to litigants. I guess as I promised, I said I'd stop after each slide and ask for any questions or comments for that matter. I don't know if anybody has any comments yet on who the potential actors are. I'll go ahead. Okay, the forum. This is the issue of where is this dispute going to play out, and who is going to be deciding issues that come up within the dispute and ultimately the dispute. And so really we've got each branch of the government represented here. The judicial branch is obvious, proceedings, lawsuits brought in federal or state courts. But the executive branch is also a forum in which a dispute can be played out. Federal and state administrative actions, EEOC complaint comes to mind as one that's perhaps more common among organizations, but all kinds of other kinds of agencies that have the authority to decide, at least as a first level, disputes among parties. And the legislative branch of government, congressional investigation, for example. Arbitration is an arena in which normally, unless you are involved directly in the arbitration, you're probably not going to see a subpoena in an arbitration, but that is another potential forum for litigating in. Okay, any questions about the fora? Okay. Now I said in the beginning that I wanted to give you guys a little bit of a roadmap as to how to assess levels of threat and urgency, and so I kind of use these little smiley face guys up in the upper right corner of the slides, and I'm going to start with what's sort of the snoozer. It is one of the more common kinds of legal actions that your nonprofit organizations will be confronted with. And generally, and let's hope it's a snoozer, but there can be some very interesting and tricky issues, and we'll talk about those. This is the one where you get served with the third-party subpoena. Don't freak out yet. And so what is the third-party subpoena? It is a command that's issued by a court to appear and give testimony at a deposition or a trial, and it's issued at the request of a litigant. So a plaintiff or a defendant in a lawsuit wants information or by way of documents or testimony from your organization. And if the command includes a request to produce documents, then it's called a subpoena ducis tecum.
And the reason we call it a third-party subpoena is that the nonprofit that receives the subpoena for either testimony or documents, and frankly more often it's documents that we find in the nonprofit world than requests for testimony. The reason is because the nonprofit itself is not a party to the litigation. It's not the plaintiff or the defendant. It's just a third party that has, or the plaintiff or defendant believes the nonprofit has relevant information, Caroline will talk a little bit more about kind of bases for pushing back and what rights or not do you have to object to that third-party subpoena. But just keep in mind, these are very common, but the nonprofit itself is not a party to the litigation. Yes. And that's one of the areas of concern that I'll talk about. Okay. Now, even though I called it the snoozer and don't freak out, it is enforceable by contempt of court proceedings. It is a command issued with the jurisdiction of the court and enforceable by a court using all the means that would be available against the litigant itself. So it's something to be taken seriously. Now,
we're going to talk about some of the concerns that arise when an organization is confronted with a third-party subpoena. Again, I just want to reiterate, kind of hitting some high points and going to be very general about it by necessity, but this is by no means exhaustive. Our goal when we're assisting a client responding to a third-party subpoena is to get you in and out and no skin off the nose. So assess whether there's any risk or exposure to the organization itself, and that's when I said a little bit in jest, you're not a defendant yet, but a concern that we try to assess is whether or not there is an effort on the part of one of the litigants or, if not a litigant, a government agency to make you a target or a litigant. And so we'll make that risk assessment. Obviously, that's something the organization itself is most important in assessing is, what was your involvement in the topic that these parties are interested in, and from a business standpoint, are there sensitivities? Is there, was it a rocky road or was it business as usual? And make that assessment, and then get you in and out. It's a legal obligation to comply, but once you've complied, slam the door and you don't have to see those litigants anymore, and that's the goal. And then, as I say, no damage done to the organization as a third party, no exposure created that wasn't already there. Okay, so some of the concerns, sort of starting at the mundane. There are debt timelines that tick the minute your organization is served with a third-party subpoena. So service will come by either a process server who delivers the third-party subpoena in person or sometimes by other means. But the time to object runs from that date, and the time to then comply with the subpoena runs from that date. And so we try to get going as quickly as possible to make the assessments we need to make. Scope is something that I noted as a concern. There is a tendency with a third-party subpoena for the litigants, that is the plaintiff and the defendant, whoever's serving the subpoena, to cast a very wide net when they're requesting documents or information from your organization. Because you're an outsider to the litigation, they're probably not familiar with your organization, its record keeping, exactly what its involvement was, or they don't care, even if they know, and they're just going to cast that net really wide and ask you for a whole bunch of stuff. And by the same token, your organization is may well not be familiar with their dispute. So you may not know exactly what it is that you have that is legitimately helpful to them in pursuing their dispute. And so there needs to be, in most instances, I find a conversation between, obviously, first between the organization and us as your counsel, but then really counsel to counsel. Say, what is this case about? Why do you want the information that you think you want? And why have you described it in this incredibly broad way when really what you're telling me over the telephone is all you're looking for is A, B, and C? And that scope can be very widely cast in terms of the subject matter or the description of what they think they're looking for, or the time frame can be ridiculously broad. So one of the things we try to do is work with you to, again, the goal is get you in and get you out with little skin off the nose as possible, including for the poor folks who have to dig up this information or, God forbid, have to take time out of their productive day to go testify. So that's what we're after with scope issues.
And Caroline and others here in representing our nonprofit clients in connection with third-party subpoenas have often been very successful at negotiating with the party seeking the information or the documents both in terms of scope sometimes, but especially in terms of time. That's probably the thing that's easiest to negotiate, is how much time you have. So just because it has a 30-day deadline on there, there's a very good chance, especially if it's clearly going to take you a lot of time to pull the information together, that you can negotiate a longer period of time. And just keep in mind that generally speaking, there's no basis to object to a third-party subpoena. Now, certainly if something's protected by privilege, like the attorney-client privilege, that certainly is not subject to disclosure. But generally speaking, there's not any usual, typical, regular basis for objecting. If you have the information that they're seeking and it's not overly broad and it seems to be relevant, then generally you're going to have to comply. You might get them, the party requesting it, to help pay for the costs of producing the documents. You might get them to negotiate the time. You might get them to be able to narrow down the scope, but generally you're going to have to comply.
Thanks, Jeff. Other concerns that we will talk about with your organization is once we get that scope under control, what is the burden on your organization of searching its records? And some of those burdens, besides just the obvious, can arise from the fact that the information that's being requested is very old and archived. It can be sort of ubiquitous, and so you're going to have to look in a gazillion places in electronically stored information, which is the so the lawyer's phrase now that comes to mean everything anywhere that exists in electronic format. So emails, PDFs of documents, anything that's information that's stored electronically as opposed to in print. And the way business is done now, that means it can be everywhere and anywhere. Departed employees, that's another issue. Gee, so-and-so really worked on that particular task force issue, but they haven't been with us for 5 years. And naturally, the burden of actually going to a deposition or trial and testifying is itself a burden. So we try to, again, wrangle with the litigants to see whether we can minimize the burden on your organization of conducting that search. Another way we'll do it is say, can't you get this from somewhere else? And if the answer is yes, then the law provides protections for the third party if they can get it from another source that's less burdensome for you, even if it's more burdensome for them. So those are some of the things that we deal with respect to burden. Another issue I kind of, the tag here was affiliate subsidiary. But really what this issue is, the subpoena commands documents and information within your organization's possession, custody, or control. And those are the magic words. There's been a lot of law developed on what that all means. But where it comes up for your kinds of organizations are things like committee work, trade associations committee work. You get a whole bunch of different folks working together on a committee, and some member of a trade association is on that committee and has information. Or documents that your members or constituents are in possession of, even if those folks aren't your employees or officers or directors or even agents, but they're your members or your constituents, are those things that you've got to go to them and get from them in order to comply with your legal obligation to respond to the subpoena. And then there is the sort of, the more generic, if your affiliate subsidiary issue, if your organization is divided up into operating divisions, or you have a parent company and the subpoena is served on the parent, but really the sub is the one that it was involved with the issue. So those are all other things that we deal with, in part to make sure that, as I say, once you've complied, that's it, you're done. They're not, oh, well, gee, now we want it from the affiliate over here. We would try to shut this thing down so that the burden on you is minimized. Confidentiality and what I sort of put as other sensitivities. It is true what Jeff says. We approach a third-party subpoena as though you have a legal obligation to to respond. That's the premise. But there are areas of confidentiality and other sensitivities where we will explore first with your organization, what are your concerns about having this information released from your hands into the hands of the litigants and potentially the general public? And then also, what are your obligations to others to not disclose the information that's now being compelled from you? So I'm going to just tick off a few to give you a feel for it, but your organization might be subject to a protective order that was entered in another case where you were a party. So you might have obtained that information under an obligation to not disclose it to others. And so we've got to make sure that in complying with your obligation to respond to the subpoena, you're not at the same time in thereby breaching an obligation in another case or to another set of parties. There might be a confidentiality agreement that you've entered into, maybe by way of settlement of another case or for some other reason. Again, we want to make sure that by complying with the subpoena that you've been served with, you're not going to breach that confidentiality agreement. Non-disclosure agreement, privacy laws. If the information that's being requested of you would require the disclosure of information that's protected by HIPAA or Social Security numbers or anything else that's protected by the privacy laws. Jeff mentioned privileges, the good old attorney-client privilege. Maybe your documents contain some advice that was given by outside counsel or in certain circumstances in-house counsel to the organization. Common interest privilege with a lot of the nonprofits, getting together with other nonprofits and talking about issues of common interest in certain circumstances, more limited, a privilege can attach. Joint defense privilege. Informant's privilege. So you're an organization that will receive anonymous tips about a company in your industry, about their practices, and there can be, under certain circumstances, privilege for that information. And wouldn't a plaintiff lawyer love to get their hands on that information? You got a tip about somebody who was doing something that violated OSHA or was alleged to have violated OSHA, and then here you've got this plaintiff saying, gee, trade association or watchdog group, let me get my hands on that information that you gathered in connection with your business, because that's going to help my case. So those are a whole bunch of areas where we will explore with you whether or not there are other sensitivities for your organization in releasing information.
Just 2 points to add. First off, Caroline referenced a protective order in the event that your nonprofit is subject to a protective order from some other case. Something else to point out, though, sometimes we're able to negotiate with the party seeking the information or documents to get a protective order in connection with the documents or information that you are going to disclose. So if the other side agrees, sometimes a court will agree to enter a protective order to make sure that whatever you disclose only goes to the parties in the litigation and it does not otherwise get more publicly disclosed. That can be very important and helpful in some situations. And also, by way of resources, I wanted to point out, since we're talking about attorney-client privilege and other privilege, for those of you that have in-house counsel, in-house lawyers in your organizations, a couple of my colleagues and I did about a 30-minute webinar yesterday for the Association of Corporate Counsel called Privilege Considerations for Nonprofit In-House Counsel that raises some really interesting and complicated issues. The PowerPoint presentation is actually in your handout materials. For those of you on the phone, you'll get it emailed tomorrow. But if you do have in-house counsel, I would encourage you to share that with them. It was really a great program.
Thanks, Jeff. Yeah, the way that we will sometimes deal with the confidentiality issues or other sensitivity issues is to ask for a protective order from the court that issued the subpoena. But my goal is always to try to, where possible, prevent the disclosure of the information. Protective order is nice if that's what the best you can do. And when Jeff said unconventional means, I do want to say my means are always ethical. But I do try to, I just feel that, the best way to protect your information is to not give it out. Giving it out under protective orders, I say, might be, the best you can do. But if we don't have to give it out, better off. Okay. Finally, I mentioned this, but I just want to circle back to it. Where we sense that your organization is potentially the next defendant in the lawsuit, or this inquiry is going to lead to another inquiry and that goal of in and out is threatened, that's where we really will bear down and do whatever we can to limit that exposure. And we also try to address if you have any public relations issues or issues with your constituents or members that arise from this subpoena or the disclosure of information under the subpoena, we'll try to deal with those. We're dealing with a situation recently where we said, we're going to try not to turn this information over, but we may have to alert the member that this information is going to be going out there because we have no other choice, and give them at least that courtesy, if not the opportunity to intervene if that's what they see fit to do. Okay, so what to do if you get the third-party subpoena? Don't freak out. Do note the date and the means of service. I got it by mail. It's got this postmark on it. I saved the envelope, or this process server showed up at the door and handed the package to the receptionist, or whatever. Those details are important to us as counsel because they do trigger the timeline. And then pretty quickly identify the contact in your business unit who is going to be the person or persons who dealt with the issue as a business matter, if they're still around, or the unit, whoever the head is of the unit who will have to deal with the business issues. And then, of course, alert counsel, your in-house counsel if you have it, your outside counsel if not. Okay, any questions on third-party subpoenas before we go on to the next item? Oh, no, excuse me, I'm going to stop myself. There is one other area when Jeff said about resisting subpoenas that actually can be fertile ground for resisting the subpoena, and that is if the third-party subpoena threatens to chill the First Amendment right of your members or constituents to associate with each other and assemble. So take, for example, the trade association. Your members have a First Amendment right to assemble and associate with each other. And if the third-party subpoena threatens that First Amendment right, the result can be, don't want to raise expectations too high, can be to resist the subpoena completely. Since we have primarily a non-legal audience, I've stayed away from boring you with case citations, but the NAACP versus Alabama 1958 Supreme Court case is sort of the one that we point to as the beginning of that test that is imposed when a third-party subpoena threatens the First Amendment right of association. And in that circumstance, if the organization can show that there is a chilling effect on the members' willingness to associate, or it will have that effect, then it is the burden will shift to the party who wants the information to demonstrate a compelling interest in getting the information and a need for the information. Can't get it somewhere else, it's important to the case, that kind of thing. In the case itself, 1958 state of Alabama chased the NAACP out of the state for not complying with their registration laws that apply to businesses generally. And after they did that, they subpoenaed the NAACP chapter for the membership list. And if you can picture the time and the place, the NAACP was able ultimately, after quite a number of appeals, to successfully argue that disclosure of that information would chill the members' right to freely associate. and the state could not show the compelling interest in getting that information, and so they did not have to disclose their membership list. But it took a long and hard struggle up to the Supreme Court to get that result. So that's where the concept comes from, but it can apply in situations involving private litigants and other kinds of situations. So member information that you've obtained in confidence, or self-critical analysis of the industry or in watchdog groups, lobbying efforts, all those kinds of things sort of, would make my ears perk up and say, let's see if there's a First Amendment issue here that the organization wants to protect. Oh, okay, yes, please, question.
What if the nonprofit is just unable to take the time to tell the results and all that? Is that a reason? I mean, it's a real reason, but was they accepted?
So the question is, and correct me if I'm getting your question wrong, ma'am, if the burden on the organization is so great they can't do what they're being asked to do, can they use that in their defense and to not comply? So the answer is maybe yes, and it would require bringing that the facts and circumstances to the attention of the court and asking for the court to either limit or condition what's being requested. So if the burden is expense, the expense would kill the organization or severely damage the organization. There's a way of dealing with that. Or it's simply impossible, you don't have the human capacity. Those kinds of factors are relevant to a request to the court to enter a protective order that would condition or limit and potentially excuse the organization from compliance.
Yeah. Question in the back of the room.
Can you talk a little bit, Jeff mentioned the possibility of recovering the costs of the search. When you're looking at a paper search for records that may be 30 years or more old. Can you discuss this a little bit?
Sure. The question is, if I may, sort of brought in, under what circumstances could the cost be shifted for complying with the third-party subpoena, and the example being given when you have very old records and they had to be dug up and photocopied and so forth. Again, so the mechanism that we're talking about is the recipient of the third-party subpoena going to the court and making a motion for a protective order, and a protective order can come in on one of these varieties that I've talked about, either limiting, conditioning, passing the cost of the compliance with the subpoena. So one of the things the court can do in weighing the burden on the third party with the need of the litigant is to say, litigant, if you really feel you need this, or you've demonstrated to me that you need this, but I can see the undue burden on this organization, I'll let you get the information from this third party, but you're going to have to pay for it. You're going to have to pay for it in the sense of reimbursement, or you're not going to get a profit on this thing, but to reimburse for the cost to the organization. So yes, there is a mechanism, which is the good news. The bad news is the burden's on the third party who received the subpoena to go into court and lay out what the problem is, and there's some expense involved with that too. But yes, cost shifting is one way a court can deal with evening out the burden, so it's not on the third party who is innocent really to the dispute.
Two kind of side notes. First off, we've had in some, not common, but some rare cases, we've had success in negotiating with the party seeking the information or documents for them to cover costs in some negotiated agreed amount. So what Caroline was talking about is the ability to go to the judge and ask the judge to order that. Another option is to try to negotiate that with the party, and we've had some success doing that in some cases. The other thing is it's another example of where the cost can be quite significant, even where it does not involve paper documents. Your question referred to paper documents, and of course that can be very burdensome. But electronically stored information can be very burdensome in some cases as well, because, for instance, say the request is going to require producing hundreds of thousands of emails, but those emails may contain certain attorney-client privileged information, communications between the organization and its attorneys regarding legal matters and legal advice. In that case, the organization, in order to avoid breaching its attorney-client privilege and keeping that protection in place, is going to need to review those hundreds of thousands of emails before anything gets turned over so that the privileged emails can be culled out of there. That is, for any of you who've been through this in litigation or otherwise, can be extremely expensive to pay lawyers to go through and engage in that process. So there are cases like that where the costs can be massive, and you simply cannot afford to jeopardize that attorney-client privilege.
Of course, your negotiation with the other side is only as strong as your potential motion to the court for protective order, because that's what they're confronted with. So, okay. So very quickly, the next slide is just a picture of a third-party subpoena. Didn't expect you to be able to read this, but so you can say, if asked, how was the webinar? How was the seminar? I saw it. I saw the third-party subpoena. And then this one is a subpoena with a request for documents, and they look similar, but they are two different animals. Okay. Next, a summons and complaint in a civil case. Okay, now we went from the snoozy smile face to the this could be a bad day that when you get served, and it could turn out to be not a big deal depending on what's at issue. But again, something to be taken seriously any time that your organization is sued. The summons itself is the piece of paper that commands the recipient to respond to the complaint. It's issued by a court, and it is the command to respond to the complaint in which the plaintiff seeks either money damages or equitable relief, which most people think of as like an injunction, or both against the defendant. It does not involve any criminal liability. It's a civil. We're talking right now about a civil complaint. David will talk about criminal process in a bit. So they're asking for a money judgment against your organization or some form of equitable relief, typically an injunction, or both. You will get this little gift probably in person served by a sheriff or a private process server. There are some circumstances where they may be served by mail, so don't blow off the ones that come in by mail. The concerns we have right out of the box is you got a real short response time, generally speaking, under state and federal laws, 21 to 30 days. You may have a public relations issue that you want to deal with immediately. Your management and working with your counsel, and for that matter, if you have PR experts that you consult with, may want to know about the dispute so that they can manage public relations issues or internal relations issues. We shouldn't limit it just to relations with the public, but internal, your organization or your membership or constituents. Service of the complaint may trigger a requirement under your insurance policy to give notice of the claims to your insurer in case there is insurance coverage for the kind of a claim that's asserted in the complaint. So we will think of that very quickly when we're evaluating a complaint and counsel you on that. And then getting served with that complaint also triggers, if hasn't already been put in place, what we call litigation hold. Again, magic words that we now use will make the lawyers in the room bristle, and the non-lawyers will learn to bristle when they hear about it again. Litigation hold is the sort of modern phrase for what parties have always been obligated to do, which is to not destroy evidence. It's fancier these days because it's so much harder to preserve and protect electronically stored information than it was in the old paper days. But it's really just sort of an extension of what we've always been under the obligation to do, which is to not destroy evidence. And once you've been served with the complaint, the information that your organization holds that's relevant to the dispute is potentially evidence. So we got a quick step to get procedures in place, if they're not already in place, to make sure that there is no purposeful or inadvertent destruction of documents, including electronically stored information within your organization.
And typically, when Caroline refers to a litigation hold, the way to effectuate that typically is that in-house counsel, if there is in-house counsel, or someone else on staff typically will send an email out to all of the relevant staff members, or perhaps all the staff members, informing them of the litigation hold, making clear what documents, what types of documents need to be preserved and not destroyed. And that's something that's, like Caroline said, very important to do right off the bat and not to waste any time. That's one of those things you need to be prepared to do in advance. Caroline, there's a question from one of our webinar participants. Is a litigation hold necessary upon the receipt of a third-party subpoena if there's little risk that the third party will be added as a litigant or as a defendant? I think the question presumes that a litigation hold only comes into place when the organization is a defendant in the litigation, but I'm presuming you would say that's not necessarily the case.
Yeah, I think so the trick with the third-party subpoena is that it may well be that your organization was completely unaware of its perceived role in the dispute, wasn't aware of the dispute, wasn't aware that it would be dragged into it. And so for the moment in time that your organization is obligated to produce information or documents in connection with the dispute, then yeah, you've got to go through those steps to make sure that that obligation is not undermined by the, probably more likely than not, inadvertent destruction of evidence. But the question has sort of a big if in there, which is if your organization isn't likely to become a defendant. That's always a very tricky area to figure out what exactly is the organization's potential future role. And we tend to sort of err on the side of caution on that. But that's where that's the $64 million question really in the litigation hold process is for that situation.
Perfect. And another question, a little bit off point, but still related to this general topic. Are there occasions when you should refuse service of process? And presumably we're talking about either a third-party subpoena or a summons served in say, a civil case.
There may well be. I can say there are situations where, well, there may well be, but it is generally futile to try to avoid service of process. They have ways. And, under the federal rules, if you avoid service of process and then they've got to go through other hoops and tricks and so forth, you could be slapped with the cost of that. And that may be a trade-off that the organization wants to make. But that's a question that I would deal with on a case-by-case basis with your counsel. I'm not saying that theoretically there is absolutely no circumstance under which you could try to make it harder. But generally, it's futile anyway. But yeah, that would be a case-by-case decision. Okay, so what to do when you get the summons and complaint? Definitely note the date and the means of service, and obviously promptly alert your management and get counsel involved right away. Question?
It's not really a question, it's a statement. The second thing you should do is call your insurance broker. If you're being sued, not that you don't know insurance and stuff, but there have been a lot of horror stories where the insurance company has not been notified.
Yeah, it's an excellent point. The point is,
Call your attorney first, the second call to your insurance.
right, second call to insurance, first call to counsel, second call to insurance broker. And we noted in the concerns, notice to insure is a concern and something that's always on the tip of our minds when the complaint comes in. Getting out quick notice, because it's not just notice, but prompt notice, most typically under insurance policies. It's an excellent point.
Have you had experience with a company having a document retention and destruction policy that benefited the company when the documents that they have a little more?
Yeah, the question is whether or not a documentary retention policy can sometimes be helpful to the organization when it's confronted with a third-party subpoena. And as a matter of fact, David's going to address that issue when he talks about document retention policies, document retention and destruction policies. So if I may defer your question till that portion of the program. Thank you. Okay. There it is. You've seen it. That's a picture of a summons under the Federal Rules of Civil Procedure. State court summonses may look different, but it's looks like an official form, and it says you got so many days to respond. It will definitely say that no matter what.
Caroline, quick question from the webinar. What if an organization learns of a threat of litigation via news reports but hasn't been served? Is it a best practice to be cautious and issue a litigation hold?
Yeah, excellent question. Let me just start by saying litigation holds are a huge area of discussion, case law, webinars, seminars. There are no pat answers, but there may be circumstances under which the getting wind of potential litigation that will involve your organization could be enough to trigger the hold, and you just absolutely have to talk to counsel. There's just I can't really give a better answer than that. It's so fact specific but the answer is yes, it can trigger the obligation to preserve evidence. So you got to talk to your counsel. With your summons, if it's in federal court, you may see on the very top of the packet this form called a civil cover sheet, and the summons might be buried underneath, and so that's why I'm showing you a picture of that. But that's the what we call process. It's the command to appear in court. Okay, I'm going to go on to writs. Writs get the sort of the smiley face. It's may not be a big deal. Don't get too hyped up about it. These writs are, a writ is a sort of generic word used. Usually it's a process from the court used to execute on a court order or a judgment. So there's been some issue decided by a court or a right adjudicated by a court, which is then enforced by a deputy marshal or a sheriff who comes with writ in hand. And an example, sort of common example, would be a writ of garnishment. The reason it gets this sort of smiley face is because unless your organization has been involved in the litigation that results in the writ and you're well aware of what's coming, you probably will receive it because you're the third party who holds property of one of the litigants, like you have an employee who is subject to a judgment, and now this third party, the plaintiff who obtained that judgment, wants you to turn over that employee's wages to them to satisfy their judgment. So I'm just going to go very briefly on this so that we can get to David's portion of the slides. But the concern here for me as your counsel is making sure that when you've got a third party's property and you're going to turn it over to somebody else, that you're not in jeopardy of now having an obligation to the owner of the property to account to him or her for that property. So avoiding the double exposure. Oh, I've given that away, but you weren't supposed to. Well, I got served with a writ. So, and the other concern is, and this applies more when there's a piece of personal property in your premises, minimizing the interruption to your business. That's always a concern I have. So, same what to do. Note the date and the time and the means of service. Usually, when a sheriff or a marshal comes with the writ, they're not going to do anything or take anything from you right then and there. You got a little bit of a buffer of time. It gives you enough time to contact counsel. If you have the contact information from that sheriff or marshal, you get their card basically. That facilitates the process of your counsel making the turnover of the property quick and easy and as risk-free as possibly can be. The picture here this is a garnishment summons. By the way, I filled these things in and made up names, and any resemblance to real people is completely unintentional. Fairfax County Circuit Court, a garnishment summons, and you'll just see on the right there's a big box, total balance due. That's the dollar figure that your organization's being asked to turn over from this employee's wages, and there are also things that you can't turn over and so forth. There's whole rules of the road, so that's why you got to talk to your counsel. Okay, I'm rushing a little bit because I want to get to David's portion. Any questions on writs, or shall we move on? Okay, David.
So good morning to the West Coast and good afternoon to all of y'all. We're now going to move into a slightly different part of the litigation stage, a different type of drama. When Caroline was talking, we were talking about civil litigation, where there were private parties sort of behind the scenes who were pulling the strings. Company X, Company Y, they're in a dispute. They want some information from you. Company X signs a piece of paper. It's called a subpoena. It goes to you. That's all Company X's dealings. The court process is involved, but Company X is the company that wants your information. This part of the conversation that we're going to have right now is about different actors. The actor pulling the strings or behind the scenes is the government, the law, as they used to say in those westerns, or the long white envelope. As consequently, you'll see the faces in the upper right-hand corner of the slides get a little bit more uncomfortable looking, a little bit more contorted. That's because you're dealing with the government, who has the power to enforce laws against you and demand a great deal from you when it comes to the information that you have. So let's talk about requests for information from the government. This is slide number 15. It's a broad term describing an official government request to aid in the exercise of the government's duties. Great. What does that mean? Well, if we go to slide 16, what you're going to get is an official-looking letter, very nicely addressed to you, very formal. And it's going to say, enclosed is a request. We're just requesting. It's very friendly. We're requesting, issued this date, pursuant to this statute. It's very official. And we'd like some things from you. And those responses are going to be accompanied by a certificate. You have to promise what you're giving us is accurate and correct. You got to do that in 15 days. All of a sudden, things aren't so friendly. All of a sudden, they're making me do stuff in less than 2 weeks, or right around 2 weeks. And they're making me swear that everything that I've done is complete, contains all the information that I have. I got to carefully read this request. I got to communicate it to the responsible official, or the failure is going to have all these consequences. This is a serious request, right? So this is what that looks like. Of course, it's the EPA sending this hypothetical request. So at the bottom, even though they're going to aggravate you for the next 15 days, they're doing so in a very green way. All of the ink is recyclable, and the paper is from the finest processed chlorine-free paper, right? So back to slide 15. That's what an information request is. Where can you come across one of these things? Well, the answer is just about everywhere. The EEOC, dear organization, we request some information on your HR policies for the following years in relation to this employee who claims that he was discriminated against. The IRS, we see that you've claimed a deduction on your income tax for the fiscal year 2011. Please, we request information on all of that, on all the deduction that you're claiming. If you're a member of a regulated industry, like the EPA, you can get these things just because you're a member of a regulated industry. You could also get one of these things for nothing that you've done at all. It just happens to be that you may have some information that the government believes that you have when they're looking at someone else. So the government can request information from you as part of their investigation into another entity or another organization. So what do? You treat this like a subpoena, just as Caroline was saying. When Caroline was talking about organizing the documents, identifying the relevant custodians, the who in your organization that might have the information, the what, are they actually pieces of paper, or are they computer records floating around wherever the computer records float around? The when, 15 days, that's the machinery that you've got to engage to get this request done, to satisfy the government, the duties that you have to the government to give them that information. That's the machinery that you have to do. There's something else you got to think about, the why. Why are you getting this in the first place? Is this the prelude to something more? Can you read in between the lines and say, really what this is part of this agency's decision to maybe change policy in the future? Are they gathering information from organizations like mine to hope to gather information so they can make a policy choice? These are the kinds of questions you have to ask yourself. Another question you should ask yourself is, okay, what are they really after? They're using all these broad words, but what are they really after? What are the hot issues in my industry, the hot issues to my organization and organizations like mine? If you can figure that out, sometimes you can unlock a very mutually agreeable way to cooperate and comply with requests like these with very little blood, sweat, and tears. So those are the kinds of questions that I think, in addition to engaging the machinery, which Caroline has nicely already summarized for us, you also think about, okay, where is this request going? How can I help my counsel really identify the key information? Maybe that will satisfy the government, and my duties to cooperate and comply will be over sooner than they would have been otherwise.
And Dave, just to interject, I've been involved in quite a number of particularly federal government investigations over the years. Like you said, sometimes the investigation may be of a particular, say, member of an industry, and they're seeking information from the industry trade association that may have relevant information about that member's conduct. And the association itself may not be a target. Or the nonprofit generally just may have information that's relevant to the government's investigation or to some future potential enforcement action or to some policy making, some rulemaking that they're engaging in. But sometimes the organization, the nonprofit that receives the request for information is itself a potential target. And the request for information may be a prelude to some later lawsuit or other enforcement action that the agency might bring against the organization. So you always, no matter how innocent you believe your organization is, you always have to assume that the organization itself may be a target, and that thought process needs to go through your minds as you're pulling together and presenting the information, because you may be able to do it in such a manner, package it up in such a way, dress it up in such a way, aggressively assert attorney-client privilege in a way that will help protect your organization down the road.
Thank you, Jeff. So one other thing that I'd like to add before we move on to the next slide is what else to do. It's not here up on the slide, but it just occurred to me. Another thing to do when you have an information request like this is to treat this as a last great opportunity to deal on somewhat amicable grounds with the government before the rheostat goes up another notch. So really, think about this as, I know this isn't the most friendliest of letters that I flashed up on the screen. It requires a lot from you in 15 days. But it's best to try and come to a mutually agreeable solution with the government at this stage before all of a sudden you get to the next stage. And what's the next stage? A government subpoena. This is a picture of what one looks like. It looks a lot like the information request that we just looked at rather. But it's a very different tone which is set when you receive a subpoena in the mail or you've had it hand-delivered by a federal agent. The boys at the water cooler in government hallways are not talking about sending out some information requests. When they're boasting around the water cooler themselves, they're talking about slapping people with subpoenas. So that's the kind of tone that we're talking about. It's a command to produce documents or a command to appear personally, to provide testimony to a committee of Congress, to a government agency, or a state legislature. So what are some of the concerns that we're talking about? Well, part of that is that intimidation factor. If you've just been subpoenaed, why is that? Unfortunately, did you not get the information pursuant to the information request out fast enough? Or does the government, sometimes Congress, is there political forces at work that a particular congressperson believes that he has to be tougher on a particular issue, and so not only is he requesting information nicely through a chairman's letter, but now he's going to be subpoenaing people. What's going on to turn the rheostat up a notch, to sort of lend this intimidation factor? Those are things that you need to be thinking of. Where do you run into these government subpoenas? Well, again, the answer is just about everywhere. In my hand, I'm holding up an imaginary stack of paper. It's 246 pages long. That is a publicly available document, which is a chart which lists all of the subpoena powers that our federal agencies have. Literally, it's 246 pages long. Almost every government agency that you can think of has, if not one, then multiple subpoena powers to compel you to have to give up information or to testify to them about information that you may have. Many committees in Congress, same thing. They have powers to command, to bring you in and command that you provide information. So what do we do? Again, thinking about the why, critical. Is this a prelude to something more? Sometimes administrative subpoenas are designed to unearth evidence for enforcement actions. If it's EPA subpoenaing you about the records that you had to submit as part of your organization over the last 5 years, they're not doing that just for fun. They probably have some sort of reasonable belief, or some unfounded belief, but a belief nonetheless, that maybe your records aren't accurate and that you may have submitted them knowing that they were inaccurate. That's the kind of thing that you have to be thinking of when you analyze the subpoena. What's the next shoe which is going to drop? Again, there's no reason to repeat ourselves. When you get a subpoena in, the best thing to do is to start that machinery going, calling up your lawyer, making sure that the right people in your organization are notified, making sure that you've identified the relevant custodians, so that when you sit down for the first time with your lawyer, you can get the ball is already rolling. I've already identified the 15 people who likely have this information. These 15 people all sit in this one area. They each have hard drives. They each have laptops that are mirror images of the hard drives. They each carry a BlackBerry, or they each carry an iPhone, which the organization pays for. All of those things are relevant to a document sweep that have to be frozen in time to comply with the subpoena. So that's the kind of thinking you could be doing when you're looking at the subpoena and starting to sweat a little bit, maybe pursing your lips like the smiley face in the upper right-hand corner.
And Dave, one thing I'd add, I don't think I've ever been involved in a government agency subpoena or congressional committee subpoena where we were not able to do some significant renegotiation of the scope and substance of the subpoena. It's very common. Government agencies, congressional committees are notorious for putting forth these sweeping, overly broad requests for information and documents that are just massive and cover more things than you could ever possibly imagine. That's how they typically operate. But what they really need and want is typically a smaller subset of that. And like Caroline was referencing earlier, if you can try to get a good handle on what the government is really looking for, you're going to be much more successful in negotiating the scope of that. And I can tell you, we've spent, for instance, recently with the Consumer Financial Protection Bureau, we're representing a couple organizations involved in investigations the CFPB has underway. We've literally spent almost an entire day in a conference room at the CFPB negotiating over the scope of the subpoena, quite successfully in the end, because the successful result of that negotiation can mean thousands, if not tens or hundreds of thousands in savings to the organization in terms of legal fees and staff time and burdens and all the rest.
So now we're going to start talking about, just for the last few minutes, about the possibility of a criminal investigation. And for those of you who are looking at your slides, now we're in the area where you've got a red-faced smiley face and he looks very unhappy. Now, there's three usual ways that one can learn that one's organization is involved, maybe not the target, but involved in a criminal investigation. One is you understand that an employee or a former employee has been approached by a government agent. Just want to talk. The next, there's some skeptical laughter in the background for those of you listening in via the webinar. Another way that you can hear about potentially being involved in a government or a criminal investigation is you receive a criminal subpoena. We'll take a look at what one looks like in just a few slides, but that's a very significant shot across the bow. You hold information which is critical to an ongoing criminal investigation by the U.S. government or the state government. The third thing is you're enjoying your coffee in the morning, you're picking up, you're going to WashingtonPost.com, and all of a sudden the doors are open and agents are fanning out across the room and taking your coffee out of your hands and taking your computer out of the wall so that they can image it forensically. That's the worst case scenario, and we'll get to that last. But so many people in the room here and many people on the webinar are probably thinking to themselves, what are the chances that I'm going to get involved in a criminal investigation? Very low, I hope. I hope it's as low or lower than getting attacked by a shark. But the thing to remember is that organizations do their work through people. And sometimes people make mistakes. And people who make these mistakes, if they're making those mistakes in the scope of their duties, then the organization also becomes looked at as part of that criminal investigation. The organization might be the victim, one might say. You might find yourself saying to the government prosecutor, what, am I supposed to go through Joe's briefcase before he leaves the door every night after work? That can be a very compelling story to tell the prosecutor. But nevertheless, you can be swept up in an investigation and have to deal with a prosecutor, deal with the investigation for a long period of time if the mistakes that are alleged to have made occurred while the employee was engaged in the scope of his duties. It's a Latin term called respondeat superior. It means organizations sometimes get the crummy end of the bargain because they're kind of swept up because of some employee's actions that took place on company time. So the first thing to do is when you hear that maybe an agent has approached an employee or a former employee, is to sort of size up the situation. What are we dealing with? Are we dealing with just a simple background check? A lot of our friends go into government. They end up get background checks. That's all totally benign. There's no reason to apply the red face that looks very unhappy to that circumstance. Also, you might not have to get worried or that worried if an agent comes to talk to you about a former employee or somebody in your organization. We understand that Mr. Smith used to work here. We're looking for his whereabouts. We'd like to talk to you about what contact information you have for Mr. Smith, so on and so forth. Again, relatively benign. Worth a call to your lawyer? Maybe. Maybe. Of course, you want to cooperate, but this is all probably pretty surprising to you, right? Well, for example, one of our colleagues here, Warren Hamill, Mr. Smooth, always has great ideas on how to comply with a government's request in a very non-disruptive, very protected manner. So maybe worth a 5-minute call to your attorney just to run by the situation is. You don't have to get to this. You don't have to leap into the air to answer this agent's questions immediately. You can take your time and say, you know what, I'll get back to you. I'm just going to make a couple of phone calls real quickly. So worth a call, sure. But let's just assume that it's something different. Let's assume that you understand that an agent has come to talk to one of your employees or your former employees, and it really seems like from what's been communicated to you that the organization might be actually swept up in an investigation. That's something different. That's something more serious. So the best thing to do at that point is, if you can trust that information, and it sounds like you can, talk to your lawyer. don't try this at home is sort of the expression. Don't try and handle this on your own time. Get a professional in, because this is a very delicate dance in my experience with how to handle these circumstances as they play out. Let's just assume that the agent already talked to one of your employees already, and you've learned of it. What do? It's sort of an after-the-fact understanding that you've just gotten. Well, why not, of course, with a professional, a specialized, experienced attorney? Let's just talk about some of the things that could happen then thereafter. You talk to the employees. What'd you guys talk about? You give them you do it in a very special way. You of course say, I'm not your attorney. We're just trying to learn what you guys talked about, so on and so forth. There's a very special way of doing it, but talking to an employee who's been talked by the agent is the way you gain information. Do you think you're going to be able to call the prosecutor and say, I know you talked to John Smith. What did you guys talk about? He's going to be like, that's between me and John Smith. I'm not going to talk to you about it. So this is the way that you reverse engineer the government's suspicions, the government's investigation. You talk to the people that they've talked about, and then you go from there. Maybe it's going to recommend to you that you're going to want to conduct your own investigation. While the government's investigating you, you may think, you know what? I'm going to try and be ahead of this information. I'm going to try and know what the facts are before this government agent and before this government prosecutor knows the facts, so that we can sit down and we can look at each other eye to eye and say whether or not there's really any wrongdoing here.
David, if I may interject, an investigation of yourself to try to stay ahead of the government is definitely, don't try this at home by yourself. That is something you've got to have counsel involved with in order to gain the maximum protection of the results, the processing and the results of that investigation to the extent that you can. Right. So let's just say you have a bit of advance warning. This agent stopped by my house. He left me a card. In his message, he said that he wanted to talk to me about working for you. What do you think about that? Definitely call the lawyer. But let's just say, what potentially the lawyer might say a little bit down the line. It might be good to tell this employee, hey, look, whether you want to meet with Agent Smith is completely up to you. I do want to let you know that you don't have to talk to him. Now, I'm not instructing you not to talk to him, but you could potentially say, look, I want you to be aware of some things. You have a right to talk to him when you want, where you want. You have a right to stop talking to him when you want. You have a right to have an attorney talk with you. Just, give these things that, of course, these people have rights. Of course these people have rights. But they might not think of it in the heat of the moment when they're surprised that some sort of agent wants to talk to them. Those are some things that, again, a seasoned, specialized attorney can work through the issues with you when something like this could happen. Now, I'm fast-forwarding past search warrant because that's like DEFCON 5 on the friendly or the unsmiling faces chart. So I'm going now to criminal subpoena, which are slides 22 and 23. Here I am at slide 23. This is what a criminal subpoena looks like. You have to admit, when compared next to Caroline's subpoena, this one looks a little scarier, right? It's got more flowery writing, and the text at the bottom of the subpoena looks a little bit more forceful. It says you have to keep the secret. This is serious business. When you get a criminal subpoena, it's usually hand-delivered to your organization. It's a very serious matter. Again, the most important things that you can do about when you get a criminal subpoena is immediately alerting counsel. This is not a problem which is going to be addressed in the near term. Government investigations, in my experience, take way too darn long. You are going to have to deal with this over an extended period of time. It's best to get someone in at the beginning and start to use a bad expression, circle the wagons, really get organized and figure out what is the crux of the government's investigation. Why am I being commanded within 30 days to provide all these documents to a federal grand jury?
So I can't emphasize enough how important it is to act with utmost alacrity when you receive one of these things. What are some of the things that then happen with, again, seasoned counsel as your guide? An informal contact with the prosecutor. Let's talk about timetable. Let's talk about scope. Let's talk about the method of compliance. What do you say for the next 30 days we just try and get you a particular type of record? It's the most busy time for our organization. It's the end of the year. There are certain missions that we just feel are absolutely critical. Can we just work on this instead of working on all of this for the next 30 days? Something like that. Talking with the prosecutor, look, why am I getting this? Am I a target or am I just a witness? Let's talk candidly about what you see this organization's role is in this investigation. Will you get a straight answer on that? Probably not, but it's a good place to start. In my experience, I'm a believer that you get more flies with honey than you do with vinegar. And it doesn't mean that you can't be firm, but you can always be friendly and firm. And when you're dealing with a criminal investigation, again, in my experience, you're always on the begging side of the table. You're not really begging, but you recognize that it's the government who has the ultimate discretion about how it's going to use its enforcement authority. The government prosecutor has the decision to whether or not to really bear down on anyone, including your organization. The prosecutors are people. You can appeal to the prosecutor by being friendly, organized, and firm in an attempt to have that prosecutor somewhere subconsciously see things your way, give you a benefit of the doubt on a subpoena, be more flexible in terms of how you're going to cooperate and comply. So those are some of the strategic things which need to go into place as soon as possible. You never make a first impression more than one time, so it's best to start with a great first impression as soon as you receive one of these very important, significant documents.
Okay, Dave, we're at the 2 o'clock mark. We're going to wrap up within 5 minutes, and then we'll get you out of here. So just bear with us. We're going to kind of zip through the rest of the slides at a very superficial level.
That's exactly right. I'll close this point about subpoenas by saying that when it comes to the government, when the government has sent you an information request, an administrative subpoena, a criminal subpoena, or is sitting down with you face-to-face, the number one thing you have is your credibility, your believability. Can the government believe that you have done absolutely everything that the piece of paper calls for and that this is the end of the story? If you have credibility with the government, which you've worked to build and preserve and maintain since the very first moment you received one of these contacts, the game is half won. So when we talk about engaging the machinery and identifying custodians and getting the iPads and the iPods and the iPhones downloaded to a website, which is all going to cost too much money, that's going to be very tedious and it's going to be a little painful. But at the end of the day, if you can look at the government in the eye and say, that's absolutely everything on this criminal, and we have cooperated with you every step along the way, it's very, very persuasive to getting your organization out of the microscope, which is where you don't want to be. So to, again, we'll move past search warrants. If you are the target of a search warrant and agents really are fanning across your office, there are big fish to fry. Let's leave it at that. If you want to know what happens if you want to know about the fish that are really big and that are about to be fried, well, usually what happens after a criminal subpoena or after a search warrant. Actually, this is true. I looked at the data just relating to environmental criminal enforcement cases, environmental crimes, about 3 years ago. 67%. In some cases, there are search warrants executed. In 67% of the cases, so almost 7 out of 10, if you got a search warrant executed at your organization, you are going to be charged. You get charged with something like that. 95% of the people who get something like that in an environmental criminal case, and I think the data was from like 2009, 2010, are prosecuted. So if you are the target of a search warrant, it's very, very serious. It could not be more serious. So what we've been talking about in the litigation world is an adversarial system. You've got somebody on the other side who says that they're entitled to something, the government, a private party, or something like that. You're at a disadvantage. You've been surprised. The way to undo that advantage is to be prepared. One way of being prepared is knowing your document retention policies. Do you know your document retention policies? Probably not. Should you know them? Absolutely yes. If you do know them, what's the logic? Test yourself. Okay, why do we throw things away every 30 days? Why? It might be a good idea, it might not be, but what's the logic? Is there a logic there? You have to know your document retention policies, because if you're like our organization, the automatic emails go out. Emails will automatically be deleted on the 1st of the month. I guarantee you, inevitably, if you get a subpoena, it's going to be served on the 29th or the 30th. And you won't even think, unless you've got it drilled into your brain, oh my, emails are about to be deleted in less than 24 hours. The emails are going to be deleted, and then you're going to have to do a lot of explaining. And a lot of explaining takes a lot of time, and a lot of time means a lot of money, unfortunately. So know your document retention policies and how you can use them to your advantage in any potential litigation situation. Same thing about confidentiality of documents. Keep your confidential documents confidential. If you get into a situation where you're going to have to be turning over documents, you want to have a really good argument about why these things are not going anywhere, because they were only issued to people with a need-to-know basis, attorneys, accountants, so on and so forth. The second thing, insurance. Insurance, the most important paper you'll never read in your life, or the most important paper that you wish you never read because they're just so boring. I've read lots of insurance policies. They're not a lot of fun, but they're very important to know about, because not only are they liability insurance, as the slide says, they're also a kind of litigation insurance. Sometimes your insurance policies will provide that they have a duty to defend you. That means they have a duty to step in and pay your attorney's fees for certain types of claims. So know your insurance policies, know your insurance broker. Yes, provide your insurance broker notice, but remember, your broker is not an agent of your insurance company. An insurance company is the company that deserves notice. So it is excellent to provide your broker's notice. It never hurts to also provide your insurance company notice directly. So know your insurance. Do they cover those risks? Do they cover the litigation that you think you might see yourself as part of?
Dave, real quickly to interject, a couple resources to point you to, since we're not going to have much time to talk about it here. There's a frequently asked questions document in your handout materials about records and information management policies that I would definitely point to your attention. This is an area, the document retention policies and insurance coverage are two areas where you can do a lot prophylactically up front to prepare your organizations. These are two areas where we work extensively with nonprofit organizations to review and revise their record and information management policies and practices, and to review their insurance policies to make sure that you have proper coverage, that you minimize coverage gaps, etc. Of course, the program we're doing next month, our seminar, is on that exact topic as it relates to directors and officers liability policies, so I would encourage you to attend that. And then finally, there's a PowerPoint presentation in the back about nonprofit insurance coverage issues that a couple of my colleagues did at an ASAE program recently. Definitely take a look at that as well.
As a final thought and a final remark, you've been a great audience. Thank you so much for listening. When it comes down to all the things that we've talked about, the vocabulary we've given you, the visual examples of some of the litigation that you could find yourself involved in the future, think about who you'd call if you were given one of these pieces of paper that you see right here. Who would you call if you received a third-party subpoena? Who would you call if you found out that you were a defendant in a lawsuit and you had 21 days to answer very serious allegations? Who would you call if you got a congressional letter that was accompanied with a press release? Congressman person X is interested in finding out more about Y and Z and X. So you've got to think about those things. Think about who you'd call. There's lots of professionals out there who want to help your call, that want to help organizations like yours get through this stuff, which unfortunately is a distraction from the whole reason why you guys have organizations in the first place. So think about who you'd call. We'd love to be one of the people that you'd like to call if you ever have a circumstance like this come up. Thanks for listening.
Dave and Caroline, thank you very much for a terrific program. Thanks everyone for participating, and hopefully we'll see you next month. Thanks.
Thank you. Please stand by.